Hello everyone, my name is Natalie, and today I will be going over Chapter 4 Racial Discrimination in the Criminal Justice System. So, first, I will be going over ethical background. So, what is equality? Equality means equal access to public office and equal treatment under the law, and equal treatment also in the process of hiring or promotion and pay. And then I will be providing you the definitions of race, ethnicity, and racism. So, race refers to groups of persons who are relatively alike in their biological inheritance and are distinct from other groups. However, biologically, the term really has no meaning. So, then ethnicity, it is also a cultural phenomenon referring to a person's identification with a particular culture group. And then racism is defined, as mentioned on the book, as social practices that attribute merit or allocate values to members of racially categorized groups solely because of their race. From Zets and Mann, 1998. And now I will be going over the historical context. I first will be going over slavery. The book mentioned that African Americans have suffered from discrimination since the 17th centuries until 1865. They were also considered the property of masters. And then the Bill of Rights also prohibited freedom due to the Jim Crow laws. The African Americans were still discriminated. And these laws maintained forms of discrimination in legal, social, and economical forms. And then we go on over to segregation, and as I mentioned earlier, the Jim Crow laws. So those laws mandated segregation of schools, parks, libraries, and restrooms. It even segregated them in buses, trains, and restaurants. There were white only signs everywhere they would go to remind them that they couldn't be together or be in the same place where whites were. And the Jim Crow laws were enforced into the 1990s. So now we'll be going over to legal court decisions, which also included racism to these African Americans. In 1896, the Supreme Court established the separate but equal treatment under the law. But this was to keep races separate, as I mentioned before. It also denied the right to vote in rural South to these African Americans. They also experienced racial discrimination in the criminal justice system. And the textbook, one example they mentioned was the Rodney King incident in 1991, where King was a victim of police brutality in Los Angeles. They found that the officers were being racist and biased, so that resulted in the police officers using excessive force. And then also another example was that Latinos in the United States also face these issues. Latinos are stereotyped, and the example the textbook provided of these stereotypes were that these Latinos were sneaky, lazy, and thieving, according to Alvarez 2000. Racial discrimination was also used in the court system. The panel of criminal justice professionals found that minorities in the New York City were only being in court from 4 to 5 minutes and only had their cases heard by the judges. To me, that means that these cases were not really looked at, and they didn't really care but to put these minorities away and were practicing racial discrimination against them, because how do you expect for 4 to 5 minutes compared to if it was a white defendant in the court, which would last even longer. And the cases were also only heard by white judges when this would happen. So now I'm going over discrimination in the juvenile justice system. So minorities also suffer more in the juvenile justice system because of their race and the stereotypical beliefs that I did mention earlier. And I did see in the textbook that that judges believe minorities could cope with the incarceration more than whites could. So that made them provide longer sentences to blacks and Hispanics. And then the author also states that it had been argued that the adult system and the juvenile justice system were completely different when you compared them with discrimination. And that was because the criminal justice system, the juvenile justice system, um, they allowed discretion, and that led to more discrimination in the juvenile justice system since it was permitted in the juveniles for the juveniles. And in the textbook, I also saw a study that was based on race and ethnicity by Kareem Jordan and Tina L. Freeberger. In the study, they found that race and ethnicity affected sentencing outcomes of juveniles, and that later dealt in the adult court system. So it followed them on from the juvenile justice system and affected them later on into the adult court system if they persisted in the if they persisted just if they continued to stay in the system. And after I mentioned about discrimination in the juvenile justice system, the book went over policing. So, police officers are more likely to use racial discrimination when it comes to decisions of arrest. According to Douglas Smith, he found that police were more likely to use force, threat, and arrest in mixed and minority neighborhoods. And the studies also proved that police officers were more likely to arrest if they felt they were being disrespected. They also found that black officers were more likely to arrest black citizens, but they feel that more research needs to be done to prove that. But in my opinion, I feel that maybe these black police officers were once in these black citizens' shoes and were once are still minorities, but they probably I feel that they want to help them and change their perspective, and maybe they think they will be able to change their mindset in some way. And after policing, they did go over prosecutorial discretion, and they conducted other studies. So, an analysis that more than 30,000 cases from Los Angeles County showed that cases with minorities were more likely to be prosecuted than whites. The analysis also showed that whites were more likely to receive plea bargain deals and shorter sentences than blacks or Hispanics. Another study from 1991 to 1994 showed that blacks and Hispanic prosecutors who requested a lower sentence for defendants usually received only 6 months less than when white defendants asked for a lower sentence. And then lastly, another study of 5,000 male defendants that Albonetti and colleagues in 1989 found that in the study they found that discrimination is also being abused when it comes to bail. So some of the examples were that blacks with the same education and background of whites and the same income with whites were still less likely to receive bail than whites. Even if they had lower offense, they were denied. Or also, if they weren't denied, the amounts were set super high because they knew these people were minorities and did not have that high amount of money to bail someone out. So after that, what was mentioned was jury selection. So, in jury selections, African Americans are also discriminated. In 1880, another case was also mentioned in the textbooks. Um, the case Stroder versus West Virginia said that having all white jurors violated the 14th Amendment. This didn't stop the states from continuing to have all white jurors. But blacks were eligible, however, to become jurors at the time, but they were still discriminated. Judges and authorities argued that they were not smart enough to handle being a juror. And also in 1986, in another case, which is Batson versus Kentucky, the United States Supreme Court lowered the standard and said if the accused was able to show that prosecution was being challenged by jurors, the judge would be able to call for an explanation, just to determine that discrimination wasn't being used. And also, after the jury selection, they mentioned economic and social factor disparities. So, economic and social factors play a role in post release penalties that increase racial disparities to especially minority felons. So, when a felon is released, they are not permitted to live in federally funded public housing, and that played a big role due to minorities having very low income, so they tend to go and try to get help. But if once they are released, these felons, they don't have access to funded public housing. They aren't able to get student loans. If they do want to go to school, they are denied for all other public benefits. Some jobs may also will not let you be a convicted felon or have a felony. So those are a lot of things that take into consideration for post release penalties. And then also sentencing, that plays a big part in racial discrimination. So the National Academy of Sciences conducted a study in 1983 that past criminal record was that past criminal record affected sentences and not race. Other factors are taken into consideration, such as pre-trial detention and the quality of legal representation. However, blacks still did longer get longer sentences than whites. For drug trafficking sentences, there was a chart that mentioned that blacks served 42% of incarceration rather than whites serving 38% of the sentence. That's 4% more that these African Americans are serving more than whites with the same kind of sentences. And then we go over on into incarceration. So another table was shown in the textbook that shows blacks were incarcerated at a rate of 3.5 times that of whites in 2013. However, the population of blacks decreased from 41% in 2000 to 34% in 2016, which improved by about 7%. So that's good. But however, Hispanics population incarceration, it remained the same from 2000 and 2016, which is not good. But then we go over to the death penalty. People take death penalty and race closely associated because blacks were usually sentenced to death by all white juries. However, a study in 1987 that was conducted by David Valdez determined that defendants charged with killing white victims were 4.3 times more likely to receive the death sentence than those killing black victims. Although Valdez concluded that in his study, the Supreme Court denied. Although Valdez concluded that in another case, the Supreme Court denied that his research was not valuable. It was in the case of McCleskey versus Kemp, and they stated that accepting Balda's claim would challenge the criminal justice system. And we go over onto hate crimes. So this is the last term in the chapter that I will be going over. So the FBI describes a hate crime as a traditional offense like murder, arson, or vandalism with an added element of bias. Racial discrimination also plays a role in hate crimes, and if the court finds anything that was motivated by bias, it will result in higher penalties. However, the prosecutor must be able to prove the motive of the accused, which is actually really hard for them to do. But one way they can that would help them would also be if the accused use language that will help the prosecutor if the language was racial slurs were used. So that was the whole that I went over the whole chapter, and I hope it was informative. Thank you.